Right, hello everyone. We should be live now, and I'm William Flack, and we've got Mike Hayden and Shannon Johnston and Caris. Is it Lewinton, isn't it? Your last name. And this is the first live stream on my channel, which will probably be why there's no comments other than from us. Right, hello everyone. We should be live now.
Yeah, so I can hear myself. I'm just
I'm
going
William Flack.
to mute
and
that.
We've got Mike. Yeah. I'll let anybody know if a comment comes up. Meanwhile, how is everybody, or how are everybody?
Yeah, I'm pretty good. Did you get that question I sent through?
I
Will,
did. What I'm going to do
Yeah,
is I'll put it
more of a comment,
into.
but yeah.
I'll get it out of my email and put it into as a comment here. Yeah, I know that's not it. That's the last week. I think it's. So, oh, here we go. I think it's the next one.
Whilst you're finding it, well, I just it's a shame there's not been any kind of LGO decision since Thursday, but I think it'd be good for us to do a couple of videos. There's that batch on, well, there's that one on back Section 21s and bailiffs and stuff, and there's quite a few on B&B things. So I've read them in a bit more detail now, so there's interesting stuff in there. There's still kind of like a couple of questions they leave open, really, when it comes to council saying you must wait to the bailiffs, and if you don't, you'll be intentionally homeless.
It happened to me again, actually, on Friday. I had somebody at Waltham Forest, I might as well name them, because they did it before, and they paid £100 compensation to somebody because they did it. And they basically said, not only did they say, wait till you've been evicted, but on the day they were evicted, they were told, sorry, we'll come back. So the person's homeless at 8 o'clock, they're evicted. And they're saying somebody will get back to you by 3 o'clock, which is pretty scary. They did in the end, but there's always a risk that somebody will go off sick or something, and then they won't get the call and they'll be homeless all weekend. But having said that, their legal department were very good, and they even phoned me at 6 o'clock to say, we're really sorry, somebody will be dealing with this.
Is Waltham Forest one of the ones that doesn't have a customer service centre? They just use a library or whatever.
They said go to the library, and then I had a really bad one with London Borough of Bexley, and it happened twice, and they sort of, when I challenged the legal department about it, they sort of played it down. But they had a security person at the homeless persons unit. When the person turned up to ask for temporary accommodation, they were told they weren't allowed in the building because they hadn't got an appointment. And then when they called the number for an appointment, they were told they had to wait 2 weeks. I think things are pretty bad, and we ought to have a meeting devoted to just dealing with these sort of gatekeeping issues. So this is your comment here,
like a naughty league table, naughty council league table.
Well, I think so, yeah. Or just tricks not tricks, just bad practice people have got into. Actually, for some reason, that one has got chopped off, so I'll put the full. Yeah, now it's got high priority on there. So this isn't a comment that I've made, by the way. It's a comment that I've pasted that Mike sent me this as an email that is quoting somebody else, and I've put it in here, but it looks like my own personal view here. So I'll just read that out. So sorry, you don't have to name names, Mike, but did you see this on a chat somewhere?
Yeah, this is on my YouTube channel. So yeah, it was not really a question as such, but I just thought there's a couple of things that kind of bounces off this that might make it a bit useful. I see we've got Cheese Faces in as well.
Welcome, Cheese Face. You're the first non-member participant in the viewer of the live stream. So congratulations and thank you. So sorry, Mike, go on.
Yeah, no, well, yeah, I just thought there's a couple of bits in there that's there's this, I've seen it a few times this week actually, where priority need is confused with kind of the housing register, the different terms they use, like medical priority, high priority, priority points, priority banding, and I realised why people get confused. Whereas within Part 7, within the homeless application process, you either want priority need or you're not. So it's not that women get higher priority than someone who is vulnerable through medical conditions. It's just one thing. However, it is easier to gatekeep someone who is in priority need through vulnerability rather than somebody who's pregnant, because I mean that still happens all the time. You hear horror stories about mums losing babies and stuff whilst they're on the streets, but you're more likely to have a midwife or a health visitor or someone involved kind of sort of chasing the council and getting them to do something. But yeah, I don't know. There's probably more to say about it as well in terms of, I guess certainly there's some more stuff I'd say as well, but I'm not going to hog the mic. But yeah, just kind of came in like that, and I thought it'd be an interesting one to kind of look at.
But it's a crazy comment anyway, generally, isn't it? Because I mean, they're both incredibly important that the person gets priority, and whether it's priority need or high priority for housing. But I don't know why the person making the comment should see them as competing somehow or mutually exclusive. That, but I guess there's strange things happening out there.
But yeah, I think it's the way council, because in a sense, it's a little bit like, when you hear people say, oh, immigrants get more priority than British people, but they don't, as kind of just their immigration status, but there might be other things within their kind of situation that would put them over. So, but I think that's the way the kind of housing shortage is done, and the way councils operate is it kind of does pit people against each other.
No,
so
you're
kind of you do realise the reality is that if someone else gets housed, that makes it less likely that you will, even though that's not the way the law works. It's the way that councils work.
Yes.
It's one of like the side effects of gatekeeping, isn't it? Where it just polarizes people against each other, where arguably the status of being homeless doesn't necessarily, mean you're going to be best friends with every other homeless person, but you do have a shared sort of experience. And if you've all been gatekept against, in theory, you should be angry at the local authority, right? They're the ones that have gatekept you and not giving you your legal duty, but you end up being angry at whether it's a charity that hasn't sort of helped you out, or whether it's, a certain cohort of people because they're seen to get housing and you're not, or it's a really horrible culture that hasn't been created by the people it's affecting. It's been created by the people it doesn't affect. And then they use that as a tool to sort of gatekeep further and to create sort of like this whole worthy, unworthy of who should get help and who's deserving of it and all of that. And I think that's one of the, I've gone on a bit of a tangent. That's one of the things I like about the law is like, it doesn't play into any of that. Do you know what I mean? I'm not saying it's black and white, but like, actually, if the law says you're not intentionally homeless, you're not intentionally homeless. It doesn't matter about X, Y, and Z. Like, that's what the law says. Get the main duty or whatever it might be. And yeah, so I don't think it's the individual who said this. I don't think it's their fault that they're thinking this way. I think it's a common thing, and I almost think it should be, because what we're talking about, like, and we talk about it so often. I think not that we make light of it, but we're so used to talking about housing and homelessness, right? But people are fighting for their lives when they're trying to get housing. Like, people are fighting for their families when they're trying to get housing. They're fighting for their mental health. They're fighting for their finances. They're fighting for their relationships, whatever it might be. This is heavy stuff. Really swore then. Not part of water, but this is heavy stuff. And so I get the anger, and I've gone off on a rant. Sorry. Someone else take over for a bit.
That's okay. Well,
nothing. You're right. Oh, sorry. I was just going to say, like, the way housing officers explain it to people, they do very clearly make it as if it's some sort of moral test, and the kind of, that's, as Shannon says, like, worthy, or you are worthy, or whatever. And certainly my experience is there is a certain types of people, certain type, people groups, whatever, will get treated better or worse than others in a council. Certainly some groups are seen as very undeserving, sometimes based on things like protected characteristics, but not always. So it's kind of, I think people do realise that, people do kind of see that in when council officers try and justify what they're doing. Because they do, that's a whole different story, isn't it? Just how housing officers justify it to themselves what they're doing. Like kind of when they're breaking the law, they almost kind of justify it themselves, saying, "Oh, this is your own fault. You got yourself into this mess," as a way of kind of sleeping at night.
Yes.
Also, it's quite isolating because these people are alone. So if you're looking at a homeless person and they look at their family support network, so say, "Oh, you're fat, can't you go stay with family?" That's often a question. Where you last resided, so they're often unsupported. So that is something I find that they use, especially with mental health. It's like there's no bedside manner either with a housing officer.
No, there isn't, and it's supposed to be. Sorry, Shannon.
No, I was going to say, you get into those weird situations, Karis, where you have to justify what might be, maybe I'm speaking about my own family here, but incredibly nuanced and complicated relationships. And you're sitting in this situation where you're just trying to ask for like the bare minimum, but you're having to suddenly delve into, 27 years worth of family drama potentially. To a housing officer's like, no, I can't stay there because, in this year this happened. Like, it's mental. Sorry, Will.
No, that's okay. I've actually got Cheeseface has given us a comment which I will put up if that's okay. It's thank you. Person X took last week's advice and included a few TH counsellors into the complaint and finally got a reply on the referral to WF. I take it as Waltham Forest rather than to me. And the person X has been asking since 2021 with MP. Well, that's good. So did the, I guess I can see if I can get a response to have a dialogue here, but did the councillors take an active part and sort of reply and help with the referral? Because or was it just you got a referral from the housing department after the councillors took action?
This was the really complicated one, wasn't it? Where they'd been in one area but were being housed in a different area. Am I thinking of the right question? Yeah.
I think there was that one. Yeah. That one involved Tower Hamlets and Waltham Forest. Yeah.
Yeah.
Sorry, it was TH. Yeah, sorry, Tower Hamlets councillors. And I think I've been thinking about this one, Mike, and I think you were right about this, and I was wrong, because I was saying, it's sort of the doors closed. But if this is a pre-localism application, then what we're saying is that the original authority that accepted the application still owes a duty to provide non-temporary accommodation in the old-fashioned sense, even though they've placed in temporary accommodation in another borough. That's what you were saying, isn't it?
I think that's what's happening, yeah. I mean, I'd say a couple of bits here. One is, and I appreciate there's a delay, so it might take us for a minute to get a response on the chat, but yeah, I think I can't remember if I said it or not. So MPs, like, although they might seem more important, they're actually not when it comes to council stuff, because they don't have any formal authority over council officers, whereas councillors do. So in one sense, they're often much better actually to go to a councillor rather than MP. It doesn't hurt to go to both at all, and you can get MPs that will put pressure on councillors to act. So, but yeah, I mean it's one sense that person's had to fight just to get a response, let alone we don't know yet whether it's actually a useful response or anything like that. But that kind of, it certainly does help. As I've said it before, like, so when I worked in Bedford, when a councillor asked a question, they would panic and sort of say, how are we going to get back to this councillor? And it's a point I'm going to raise in the housing committee in Bedford next, is that there's evidence there's council officers, senior council officers lying to councillors. So I'm going to make a bit of an issue about that, really. But yeah, I mean, going back to that point, Will, so because I think we've dotted around that discussion before. Because I would say Section 193 is essentially is a duty to provide settled accommodation, but you disagree with that. So we're talking after Localism Act here. But because I would say that duty is not discharged until either there's been a 12-month assured short-hold tenancy offer or a Part 6 offer. So in one sense, you might have someone in this situation where they might have been placed in temporary accommodation for many years, but the council still has a duty to provide settled accommodation, either through that 12-month offer or a Part 6 offer. But again, you kind of, I think you've differentiated something which I didn't. It was a bit of a nuance which I didn't understand. Is that does that make sense?
Well, yeah. I mean, are we agreed that if the person gets given an assured short hold tenancy for more than 12 months post Localism Act, that's a discharge of a Section 193 duty. I mean, subject to it being a lawful.
Yeah, but it wouldn't be like an assured short hold tenancy that just happened to go past 12 months. It would need to be from the start a 12-month assured short hold tenancy. Yeah, if that makes
Yeah. The thing is, I was just trying to distinguish between permanent and temporary, in the sense that permanent used to be shorthand for a council tenant. You'd get your temporary, which was your private or non secure, and then you'd get a council tenancy or a nomination to a housing association. And I guess I should check the fine print on this, but it's just in practice these days. It's just I find that I'm having to advise people to accept, if they can get a discharge of into a private sector property. But maybe I should check the wording and whether it's. I mean, it's rare that you'd get an assured short hold of less than 12 months, and they would normally try. I mean, I can't see why a local authority would say to a private landlord now, "Can you give us a non-secure temporary accommodation, or would you mind giving us an assured short hold, because that way we can discharge the whole duty." Am I missing?
But I think this is where so I think that's I think what you just said is that's the law, but I think what councils are doing. So I had a case with Northants Council where basically there was a lot of messing around with temporary accommodation, interim accommodation, should I say, like multiple moves, even though we kind of made it clear that the family are affected by disabilities and that needed to be minimised. And then they basically, the way the council portrayed it was, we're going to move you again. But actually what was really happening behind the scenes was they were giving them accommodation that's likely to be available for 6 months. It was like a Midland Heart property. I really dislike Midland Heart based on this experience of them. But and it was kind of like, kind of, they didn't really kind of make the significance of that out to the person, because I was still sitting there thinking, yep, this is going to be main duty. The relief duty is almost up. And actually it wasn't. And one of the things the LGO picked up on was the fact that when they offered that accommodation, they kind of weren't clear what it was. And I think what you're going to get is people who are already actually had the main duty accepted for them, and yet the council will kind of ring them up and say, look, we've got this tenancy available for you now, you better take it. And they don't, they might not even lie about it technically, but they kind of mislead the person to think this is the main duty offer. Really, it's not. By then, they're then, if it's for a rent deposit scheme, they're not homeless anymore. So in one sense, the council, I guess, effectively has ended that duty, and that person is then in accommodation which doesn't meet those standards of 12-month short tenancy or whatever. So I think that will be happening out there in the mess of the convoluted stuff with the Homelessness Reduction Act. I think it's just very difficult to really kind of keep track of everything, and councils certainly don't tell people what they're really signing up to, and they'll certainly make out that if the person turns down an informal offer that they're going to be ending everything, and it's not the case at all. It doesn't make a difference in a lot of cases. So there's a lot of skullduggery that goes on, I think.
Yes, but there always used to be, and before the Localism Act and before way back, there used to be a trick that would be that if somebody applies as homeless, and there was a duty under the 96 Act to give advice. And so they would say, "Oh, we found there's an assured short hold tenancy going down the road. Would you like it?" And the implication would be that this was part of the temporary deal. And then they'd say, "Yeah, I'll take that," because they were getting evicted the following week. And then they'd say, "Okay, great, game over. You're not homeless anymore. Goodbye." And that was a trick people got caught up in. So yeah, you have to watch it. But I think maybe I'll do some research and just satisfy myself, and maybe mention it in another session as to precisely what it is that you've got to be looking for to see if that offer you get is, you can say, no, this is temporary, I'm entitled to get something else, or whether they can actually say, that's it, we've accepted a 193 duty, we've given you a private place, that you won't be hearing from us again for a long time, if ever.
There's some additional small print with that, because if it's done as a 12-month, if it's done as a Section 193 discharge and it's 12-month short of tenancy, they also need to be told at that point that if they become homeless unintentionally within 2 years, they'll retain the priority status. And again, I had that one of the early complaints I made back in Bedford, like in 2015, where they kind of, they just basically tricked someone into taking an offer which wasn't as good as what they're owed. And one of the things I got upheld in that complaint was the council accepted it should have told him about, effectively by shunting him into this private rented place, he lost that 2-year protection period. And actually by making the complaint, they then reinstated it. But it's very rare that that's ever going to kick in, but it is still a good thing to know about. It's quite an obscure bit, but it's still useful.
I'll just put, thank you. I'll just put Cheeseface's further comments on here just to update you. So we've got, he said that the councillors in Waltham Forest said they couldn't help because the duty was owed by Tower Hamlets. Tower Hamlets added Tower Hamlets councillors into an email and received a reply from a Tower Hamlets housing officer. No Tower Hamlets councillors' names on it, however. And then it goes on. The reply was the housing officer asking who to make the referral to in Waltham Forest. So not great, but a reply nonetheless. Well, I suppose that's looking on the bright side of it. But I think going back, because it was Tower Hamlets that placed in Waltham Forest in the first place, wasn't it? So I think somebody has got to threaten Tower Hamlets with some sort of action if they don't, or a formal complaint, if they don't get on with discharging the duty which they've not discharged all this time. Yeah.
Because I think based on our understanding of it, Tower Hamlets are the one with the duty. If I remember correctly, is Tower Hamlets owe the Section 193 duty, and they're saying, "Oh, we couldn't possibly find you accommodation in Tower Hamlets because it's not safe." And they're saying, "Well, we can't find you accommodation anywhere else," but they can legally. They can find you accommodation anywhere they want. And as we talk about a lot of time, most of the time that's what councils do. So they're just trying to have their cake and eat it by the sound of it, and just trying to make out like they couldn't possibly help, but really they have a duty to help, and they definitely can help. I bet in the time that this person's been in contact with Tower Hamlets has housed multiple people outside of the district. So it sounds like, I think, complaining and kind of something I responded to someone today is if you make a complaint and don't get a response within the time frame set out in the complaints policy, don't wait any further. Just make a second stage complaint. And said I made a first stage on the 1st of January. The policy says that you have to get back to us within 15 working days or whatever. It's now been that you haven't had a response, so I'm making a stage 2. And they might then actually give you a stage 1 response. You kind of have to go with that, but you can kind of get through. Again, it's Northampton again. Actually, I got through pretty much the whole complaints process without actually having a response. I just kind of went, just put it on the calendar. Right, I need to make the second stage. Then I need to go to the LGO. I think it was in the 3-stage complaint process there, and the LGO basically came back and said, they've not responded in time. We've now contacted them, and you need to wait for their final response before we get back involved. And that's what happened. And they did get back involved, and they upheld it. But that's the game these days. They just kind of make it as difficult as possible.
Yep, we've got another question, and this time it's from Dan, who has asked, what does it take to get a council to issue an improvement notice? Bathroom roof has been propped up with a metal pole for a month. It's blocking the bathroom door so it can't be closed. Well, that's a good question, I think, in that it's something that occurred to us in us being a group of lawyers who were discussing it ages ago when they brought in this business back short hold tenancy notice of seeking possession not being valid if a notice has been served. Now, off the top of my head, I think an improvement notice is one of those notices. And so the question is, let's just assume, forgive me if I'm assuming too much, but the bathroom roof being propped up with a metal pole would be grounds for an improvement notice being served. So just for the sake of this question, what do you do if you've got a valid ground for having an improvement notice served, but the council won't do anything about it? And the answer, well, I guess we're back to the usual duo of formal complaint or judicial review threat, because they do have a duty to, or a discretion. I mean, I suppose they don't have a duty to serve an improvement notice every time the grounds are made out immediately, but they'd have to explain why they're not exercising their power to do so. What do you guys think?
I think taking photos, when you say metal pole, I'm thinking like an acro prop bar, one of those ones that kind of you screw and it goes further and you kind of use it in construction to keep the roof from falling in. It just seems to me to have an acro prop in a house seems to be deeply unsafe because someone just doesn't know what it is and has a little unscrew or something and suddenly the roof falls in. Just seems. I mean, so I think photos just to kind of it all comes back to that kind of a picture speaks 1,000 words. When you're communicating, when you're making a complaint, a photo of the actual conditions can go a lot further, particularly if you're involving counsellors who, again, they know that a picture speaks 1,000 words. They know that sort of picture getting its way into the public domain in the press or something would look really bad. So I don't know what the law is at all on this issue, but I think in terms of if I was wanting to raise it with counsellors, and a lot of counsellors these days are talking a lot about this sort of thing like disrepair and so on, then I think taking photos of it and on that video I did a little while back with the lady who was homeless, took photos of the roof bowing and from inside and outside and all that sort of thing, and it did the trick. So I think that's kind of that was a non-legal way. That's not illegal, but it's a kind of it was outside the legal formal way of dealing with things, but it still worked. So that just that's all I can say about it really. I think that would potentially be something I would do. So it says it's not excluding. So that's a serious safety risk because if they come this, they can just literally fall. They're heavy. If they what I think they are, that probably weighs like 20 or 30 kilos. It could kill someone probably. Certainly a kid. Sorry, Shannon.
No. So I think I've just had a quick Google. I won't lie, but it does sound like a Category 1 or Category 2 hazard. And I'm actually on the CAB website because it helpfully explains exactly what an improvement notice is. But within that sort of, it does say if your landlord doesn't do the work, your landlord can be prosecuted and fined for failing to comply with the terms of an improvement notice. Now, I wonder if it's almost, again, like thinking outside the box, but going to maybe CAB, because they obviously, different areas will have different advisors, but maybe approaching the local authority's legal team rather than the housing team, or approaching the environmental health team and CCing in the legal team, the housing team, like emailing everyone, which sounds a bit dramatic, but we've certainly worked with people who every week they add another person into the CC, please see below, and then the next week they'll add in another department, or it'll be the next manager and the next senior manager after that. And it does have an impact to sort of have maybe like fresh eyes on it. Paris.
I'm sorry. I was just going to define the hazard. So it's anything that causes physical harm, mental harm, or that is a risk to you, that how the property is built, and that could safety cause a problem. So that's something you definitely need to say to them, and consider if your local authority owned house or if it's a private house or private rented.
Because if it's a local authority property, is it still the case that they can't really serve a notice on themselves?
Well, they don't like to, do they?
No, but legally,
that's always complaining. Yeah.
Can you legally do that? Because if they take themselves to court, it gets a bit. It starts getting a bit nonsensical. The thing always used to be that local authorities didn't serve notices on themselves, not just because it's there, so somebody from down the corridor who'd get into trouble, but there was a legal difficulty in prosecuting or suing themselves. But I may be wrong. But I think the simple answer, I mean, I think where they have, I mean, it's a fairly clear duty, isn't it? Where they believe there is risk, we could read into that where they have reason to believe there is risk. Because if you look at something which you should believe is a risk, you can't say, well, I don't believe it is, unless you've got a good reason. So I think a complaint to somebody senior would result in them saying, look, please, will you go and look at this and deal with it? Or a judicial review threat would get the same thing, I think. So hopefully, Dan, the answer to the question is a complaint or a threat of judicial review proceedings would certainly get them to serve it or give you a proper explanation for why they're not doing it, rather than just not answering the phone or whatever, which can be the usual response if you're just politely asking.
If it's like genuinely a safety thing as well, is it something that the person can raise like a safeguarding alert against themselves to the local authority? Again, just to add a bit more pressure of like, actually, I'm struggling to keep myself safe here because of this X, Y, and if it is having an impact on your mental health as well. Again, just thinking to like try and get the local authority to listen, because if I remember correctly, this is a private landlord.
Yes, it
Previous
is.
questions
Yeah.
are, so yeah. So I don't know if that would be helpful or not as well.
But yeah, I think it would. It's
On
usually. Sorry, go on, Mike.
I was going to say on a related question, like, so if it's a private landlord, so let's say they were doing actual, real building work rather than just kind of propping up the roof, like, and they had to kind of decant the property. Would it be the landlord would presumably be the one who had a duty to accommodate the tenants whilst so let's say the roof was about, suddenly became aware the roof was about to fall down. The landlord panics, says, right, I better make this safe, better get everyone out. Would that be the landlord's job to secure alternative accommodation for the tenants whilst that work is undertaken? I mean, it doesn't sound like this is actually happening right now. It sounds like they just put a prop in there and walked out. But in that situation, how would that work?
I think it'd be the local authority that would have the duty, because subject to what anyone else thinks. What? Go on.
I don't know if I'm being difficult. I thought it depends on what's in the tenancy. So I feel like some tenancies with private landlords will have in there, if like there's disrepair or major works that need to be doing, I as a landlord will put you in X accommodation for a maximum of X amount and cost, and it'd be in there. But if it's not in the tenancy, then I think it falls to the local authority. But I think again it's going to be a difficult one because the local authority is off the bat going to say, well, you're not homeless, even though you can. Like I saw that with, and I know it's different, but with closure orders, and it becomes difficult in terms of you're still liable for rent when the landlord's doing work, and then you're not eligible necessarily for the housing benefits for temporary accommodation. But again, they have to make it affordable. So I think if it's not in the tenancy agreement, it would fall to the local authority. If not, I think it's down to the landlord. I'm not 100% on that. So yeah, not legal advice.
I don't think it comes up that much in practice, because normally if you couldn't occupy your home, you'd probably go to the local authority if you were in priority need, because you'd have to get an injunction against the landlord, because the landlord's a private. Well, if the landlord is a private individual, you would then have to go for damages against the private landlord for the cost of putting yourself in the accommodation which they should be providing you with. It all gets a bit messy. Or you could get an injunction. It's quite difficult to get an injunction requiring the landlord to go out and rehouse you somewhere else. You'd be better. It's much easier to get a public law remedy against the local authority, but I guess it could be a problem if the tenant isn't in priority need.
It is, I think, Sharon, you're right. They don't have a duty to rehouse you unless it says so. But you don't have to pay the rent while you're there, and they have to get a court order, don't they, if you don't leave them to do the work. And it would be down to the council because it's unreasonable to continue to occupy.
Yeah.
There's a nuclear option as well on this, which I haven't really talked about before. But if I was in this situation, I'd do this because I'm familiar with the committee settings. Because the reason I say this is I've been listening to the June Housing Committee in Bedford today whilst I was painting, and there was a prolonged discussion there about disrepair issues. And I know if I was, if I was going as a member of the public and sent them some photos saying this is what I've been put up with, give them a timeline of it, but essentially ask the question publicly. You can ask that your name is not published, or and you don't have to be there. You can email it through. You have to live in their area to ask a question in the council meeting like that. But it just basically, again, it just escalates it high. It's the same. It's like it copying in a councillor, but on steroids or whatever. Because again, they can't. If there's photos as well, it's then almost in the public domain. So you don't have to you don't have to be identified when you ask the question. But it's just maybe a quicker way of just getting there. And I don't know if this is the best way forward in this particular situation, but it's an option for people to do if it really nothing else is really working. Then just to kind of go to the housing committee and might not be called housing committee, it might be called something else, but there will be a committee that covers housing issues, and you could ask it there. And effectively, then you've got multiple political parties all trying to score points over each other. and they'd kind of almost at that point fall over themselves to be helpful. Or that might happen anyway. I can't guarantee it, but that's something that I don't know. It's just kind of, it's all about kind of shedding light on and kind of just exposing issues in a way that they can't hide and kind of sweep under the carpet. So yeah, it's just a thought.
If there's no more comments, so I was going to try and see, just to try the formatting. I may throw everything out. I'm going to try and move on to a different scene in terms of this. If I go to here, we should all still be here. No, is it? Oh, that didn't work because I wanted to try and share a screen. Oh, no, now you've all disappeared. Sorry.
Better for you, Will.
Yeah. That's a bit freaky, isn't it? I'll go back. There we go. Actually, maybe I can do this. I can. What I wanted to do is share my screen, which I can do in a different box, but I don't want to.
Whilst you're fiddling with it, Will, there is a kind of follow-up comment to the previous situation we were talking about. I've got something else to say
sorry,
about. So
Dan's just come back.
it's because no. So someone just said in terms of the Tower Hamlets, Waltham Forest. So
sorry, I'll come back to you, Dan.
Stage 1 response took 6 months. Stage 2 another 6 months, unfortunately. So basically, you would be well within your rights now to go to the LGO now, and the LGO would then kind of throw their weight behind it. And again, they might say you need to wait for the Stage 2 to actually come back, but by that stage, the LGO is chasing the council. And then there's another bit in there. So where's it gone? Now on so the reply was the housing officer asking to make referral to Waltham Forest. So not great, but so again, based on my understanding of the situation, Tower Hamlets cannot force Waltham Forest to do anything. It's because it's Tower Hamlets' duty. But I think we talked about last week about the possibility of a reciprocal arrangement, and that's entirely possible. Again, that's about political will. That's about kind of whether they actually want to actually follow the law or not. So that could happen if this person wants to be in Waltham Forest, then actually that's an avenue the council would be open to. And if the complaint works in terms of kind of getting Tower Hamlets to actually kind of kick into gear, then that might be one of the best ways that they can go forward. And yeah, so I don't think we'd actually kind of specifically talked about that aspect of the question here, but that's my thoughts about that bit anyway.
Okay. I'm not going to try and do this to share the screen because I'll just make a mess of things. But there is an interesting case on Nearly Legal. It came out last night. I don't know if anyone saw it, but it's called A Very Unfit Home, and it's a judgment where somebody was actually living in a converted shed in somebody's garden, and they got £50,000 damages over a period of 4 years. No, £57,000. But it just shows you how bad, if you think things are bad, you think in the private sector, they're probably much, much worse than you imagine, because this is literally a garden shed with a toilet fitted in and some bits and pieces, and it's just dreadful. But it's amazing that the landlord actually contested it.
It was interesting, because the tenant hadn't exactly conducted himself brilliantly, because they basically knocked the wall through to the toilet or the storage area at some point without the landlord's permission, and then hadn't refused access to the workmen, but hadn't been terribly cooperative. So and that was interesting itself, because there'd been a couple of times where the tenant had kind of said, I can't bother to let you in or whatever. The landlord basically just then gave up, and the courts basically said, no, you shouldn't have given up. You should have kept trying. You should have kept trying to get your workmen to go and fix this issue. So that was interesting in itself. I think just kind of the fact that you see that with local authorities as well. They kind of try and ring you once, and then you don't pick up or something. Like, wow, that's the end of that one there. Actually, it's still on them to really kind of keep trying.
Yeah. That was one bit of news, and I'm still. Has anybody had a closer look at the new post Section 21 no fault eviction law? No.
No, I'm waiting for someone to spell out to me what it's going to be replaced by, because there is going to be something in there which allows landlords to get their property back without reason. I think there's stuff in there about it's a bit like there is in the moment. So, if the landlord's going to say, I'm genuinely selling it or I'm genuinely moving back in, there'll be some kind of like penalty if that's not the case. But it doesn't seem like that's very enforceable. So I don't know.
No. There is
Still
actually,
not.
Nearly Legal's done, I know you've probably seen it, he's done a review of the actual bill that's come in 2 parts, which I haven't read in detail yet. But to me, the key question is, I think I've said this before, is what do you do if the landlord says, I want to sell the property or I want to move in, and gets possession, and then you find out 3 months later that it's on the market again and he's renting it for higher rent, and he actually didn't want to move, he didn't really want to move in, he just lied about it. What's the penalty? Is it because you'd think, well, that's perjury because you've obtained a possession order based on false evidence. But I can't quite, and that's a criminal offence. Like Jeffrey Archer, if you remember, went to prison for that. But I can't see that happening for landlords just telling lies to get a possession order. But it's quite an important one, isn't it? Because otherwise everybody will just be saying, and you can't prove what you want to. You can't prove something that's an intention. So we'll have to come back to that and see. But presumably it'll show as well that you remember Michael Gove said they were going to get rid of no fault evictions 5 years ago, or whatever. But then they said, oh, we have to make reforms, unspecified reforms to the court system so that it can cope with this. But presumably, if the new government can pass this without making any changes to the courts, it shows that was a load of, well, I suppose nobody really believed Michael Gove.
We already knew that, yeah.
Yeah. Yeah. But it'll be interesting to see. The one thing's for sure, it's going to be happy days for lawyers for quite a long time, while lawyers get paid to try and sort out what these things mean in practice. But it is a wonderful thing that they're getting rid of Section 21. I mean, it's been a stain on our system for a while. I'm so fed up with having to tell clients that you've got no rights. And sorry, the fact that you thought you could be here the landlord told you you'd be here for ages, and none of that matters. And you were foolish enough to sign one of these agreements in good faith. Because they say, oh, it's just a technical, it's just for legal purposes, we need you to sign this agreement. But even if you didn't sign an agreement, you're still in a short hold tenant by default. So I'm really glad to see it go.
Going back to the kind of disrepair and the category 1 hazards and stuff, Will, have you got any kind of lawyer, like barrister type buddies that might be able to kind of come onto one of these videos and just kind of talk more about what these different terms mean and kind of what people can do? Because I find it interesting, if nothing else.
Well, yeah, it would be good. I mean, I do know barristers and other lawyers who would be able to comment on this. Maybe one day we could see if Giles Peaker wanted to get involved himself, or Nick Bano, who you may remember from other cases, is the barrister that got got the judgment on the Shed case, and he's pretty good on public law stuff as well, so he'd probably know the answers to the questions about what do you do if you really want to get the local authority to deal with all this. Well, I mean, maybe you do. It's particularly important with the Section 21 reason, but it would be good. Ideally, local authorities should be doing this. People shouldn't have to go to court because they can send surveyors. In the old days, they used to be able to send environmental health officers around and sort these things out. So yeah, I will try and get into that. It'd be interesting to know if any of the sort of 3 people who are watching this today have any ideas as well. We could come up with any comments about subjects you'd like to see covered in more detail. Please do put a comment in there, and I'll try and come up with it. I think Mike and I have been talking for a while about vulnerability. We're going to do some more on that. And I think suitability, affordability are things we want to talk about. But there's plenty. I see things most days and I think, oh, that would be a good thing to talk about. But anything anybody else thinks of?
You could, on the disrepair note, talk about the, I may be saying this wrong, but the AWAB's law, and
Oh,
part of the
yes.
renters bill was, putting in, like the landlords will promptly tackle hazards and make the home
Definitely.
safer. So that's remains to be seen. So that is something they're putting into the renters bill. New
Yeah, it would
vision.
be good to do that.
Sorry, Bob.
No, go on.
I was just going to say, so this kind of this is interesting or not, but so Bedford, so Shannon and I, next housing committee is a week on Wednesday or something, and there's kind of like a whole bunch, there's kind of these different areas of like thing, so Bedford, that's pretty much anywhere. If you want to get housing improved, we need to increase the amount of social housing being built rather than affordable, but affordable would be better than nothing. We need to get empty homes back into circulation, and we need to get existing, particularly private rented accommodation, the quality improved. Now, if there's more attention on things like with the kind of damp and mold stuff, I think what it's going to take is local people basically getting photos, kind of getting together, and kind of getting some solidarity and kind of actually putting that stuff towards a council, like in an organised way. And I think that could actually be a very effective way of doing it. I think that's what I'm hoping, certainly in Bedford, that we do, because there's a few organisations in Bedford that every so often they'll kind of post a video of like, water pouring through a light socket in one of their clients' properties or something like that. But I think actually that would be a very effective way of doing it, because I think again you get into a situation where potentially the law itself might be great, but because councils can't be able to enforce it, it makes no difference. So unless you've got that public interest in it and kind of local people actually raising issues that can't be ignored, I think it could all kind of be just a bit of an exercise in lawyers getting paid for stuff that doesn't really make a difference. But I think I'm certainly quite confident in Bedford that we're going to get some progress with that stuff. There's some other things we're going to work on as well. So just something again, I was watching the last committee today. About a year ago, we asked the council if they would give training to their councillors, because councillors need to know this stuff, and they ignored us pretty much at the time. But then suddenly they came up with the bright idea of getting their councillors on training. So those kind of things do work, and I think everywhere, there's 300 odd local authorities in England. There needs to be people in every area just kind of taking on the council in this way. Otherwise, I think this stuff just becomes academic. But it can be done, really quite remarkable outcomes you can get with minimal effort, really. So I just still say that,
We do need some transparency in the repairs that they do, the costings, where they get their equipment, so you don't have the Grenfell cladding. They need to be more transparent in what they're using, the equipment they're using, who they're paying, so they're not paying their mates. So you need transparency, and that should be published.
Because in Kensington, basically, it seemed, I haven't read the report's like 1,700 pages long, but the inquiry basically said, essentially what Kensington said is like, we want it cheap. And the developer said, well, it's not going to be ideal if it's cheap. And they said, yeah, we don't care, just get it cheap. And that was one of the many, I watched this, there's the Art of Law channel on YouTube. This guy called Alan Robert Shaw, he's kind of an older guy, but he's cool. He explains different things in the law, and he was basically saying that could potentially be misfeasance in a public office where they know full well that the kind of the procurement rules or something were being broken when they brought in that cladding. I don't know if you know how much bad it was. You know what Celotex is? Yeah, it's like foil with like foam in the middle. The fire testing, they peeled the foil off, tried to set fire to the foil, and it's foil, so it didn't set fire. But the bit in the middle is obviously highly flammable, and that was their test. So again, I don't think we're going to see them going to prison over it. But yeah, that was something that Kensington were up to, Kensington and Chelsea.
Go
on.
Now, I was going to say, and the most thing that probably everyone hears is when that they paint over mold. So when they come in and they just paint over it, and that should be, there should be a stepping stone and a grade of the mold of how they tackle it. So if they go in and just paint over it and go, oh, we've treated it now, oh, it's just come back, that should be also transparent of how many times they're called into the same property to get the mold tackled.
Yeah.
It comes back to that kind of like making the register of rogue landlords actually working. Because again, in Bedford, we've FOI'd it and there's no one on it. They've got a register, no one's on it. well, it's not working then, is it? Because there are definitely some rogue landlords in Bedford. So again, but I think it takes that kind of public interest. Honestly, we'll do some. I think me and Shannon will do some videos about the housing committee, because the questions we've been asking housing committee is by far the most interesting committee in Bedford in terms of what the questions are asking, the discussion. There's actually kind of genuine debate going on. Whereas like 5 years ago, they were just it was just wet letters stuff.
I don't know if I've got my cynical hat on today, but one of my concerns about that sort of thing is like, is it going to create almost a whole sector of charities that are well-intentioned, but essentially end up getting money and then spending the money, but on things that they never needed to? I think we sort of saw that with supported housing, didn't we? Where like supported housing is such a massive sector now that I don't see a homelessness sector without supported housing. Because we've told ourselves that people need supported housing. There's money in supported housing, as bleak as that is, but you know there are profits in that. And my concern around like the repairs and stuff is like, is that going to be like the new thing where actually we have charities dedicated to damp and repair, and off the back of it, like I want to say that's a great thing. Like, you know, a charity's doing really well, but it sort of worries me in the sense of like, again, we're taking accountability away from people that need to be held to account, and then you lose that transparency as well, don't you? Like, because, and again, it sounds so cynical, but I think with charities, although they have to be transparent to an extent, because most charities are well-intentioned and are trying to do good, actually you do kind of lose transparency, because no one wants to call out a good charity, right? Like no one wants to say like X amount of charity, actually I think you're a bit dodge because you're making money off of poor people. No one ever wants to say that because you feel like a wrong'un, right? But actually, like, I do worry it could happen. And so again, and I might be really thick and maybe I'm going off on a slightly different tangent now, but with like the abolition of Section 21s, I'm not saying it's a bad idea, and I get why it's a good thing. But in my head, I'm like, well, if we abolish no-fault evictions, essentially, are we not then just creating loads of at-fault evictions? And are we not going to see councils then say, oh, you're intentionally homeless because of a really small, like you've got a mental health issue and the landlord couldn't cope with the reasonable adjustments, or we're going to see more discrimination and more, I don't know if that's my, because I'll be honest, I haven't read Renters' Bill as it updated and everything, like, so I don't know if I'm being naive or, yeah.
I think you're the opposite of naive. You're being cynical, which is very healthy.
Yeah, I think that the thing about you're going to get, so landlords, the only way they're going to get people out is by saying that they've got large amounts of rent arrears, essentially what, you know, through the Section 8 mechanism, which again I'm not very familiar with, but so I think, yeah, absolutely. I mean, I think the thing is councils were quite able to find people intentionally homeless from no fault evictions anyway, so hopefully that might, but I think you're right. I think that's what you need to look out for, is that it's going to make it easier for councils to go down the intentional route. And ultimately it comes, if we go back to the kind of like big picture thing, ending Section 21 evictions in itself won't do anything to reduce homelessness, because you've got the same number of properties and the same number of people.
Yeah.
I guess, Derek, I mean, there's kind of arguments saying, well, actually this makes it less attractive to be a landlord, so you get more landlords selling up, which could have a trickle down effect. I don't know, but yeah, I think that's something to definitely look out for, is councils finding, you know, getting more intentional decisions through, or trying it.
Do you get less landlords, or do you just get a smaller amount of landlords that own more properties, right? Like, and again, then you've got like what you said about like 8 months of arrears instead of being a reason. Well, actually, you've stopped a decent landlord from saying, look, I know you can't afford this now because you've just lost your job, so I'm going to serve a Section 21 so you can, you know, get some help from the local authority or whatever. I'm not saying that happens, and maybe I'm now being too optimistic that there's nice landlords out there doing that. But yeah, no, stop talking.
It'd be interesting to
and
see
it's
what
also
the
raising the
effects
risk.
are.
No.
Sorry, Caris.
Okay, and also they're not making provisions for the rise in illegal evictions. wouldn't they?
Yeah,
So you're
that'd
just
be
going to
true.
let people change the locks and put their stuff out. And then, like you say,
that's-
well, you're intentionally homeless.
That's going to happen to the most vulnerable people, right? Like that's what all of this happens to, is the most vulnerable people with the least amount of advocacy in their life. Like, yeah.
Nick Banner would be good to talk about that one as well if we get him on, because he wrote that book against landlords. He hates them.
Oh yes,
and they hate him.
I've got to finish reading that before I can ask him in faith to read it. I mean, it's a really good book. It's just I haven't got time to read much. Maybe it's on audiobook now, because I find that's the only way I can read a book. If I can go for a walk and listen to it on headphones. So
Yeah, I don't know.
I think that's probably, we're getting towards the end now. And I mean, I hope that was okay for you guys. I mean, I've learned some lessons. I mean, obviously, this isn't my sort of optimum thing that I was aspiring to. It's a start, and I'd be grateful for any feedback anyone's got. If I mean, however cruel it is, and then I can learn from that. I would like to be able to share. What I'm going to try and do next time is have a shared screen so we can be looking at more than just comments. Oh, thank you for sticking around, Cheeseface. I wasn't sure who was still there. And we can hopefully build on this. And what I'll do for the next session is I will promote it more, because I think I've got to the stage where I can see now that I can actually broadcast one of these, and also I can see how I can improve the layout so it looks a bit better, make you guys a little bit bigger on the screen, for instance. So hopefully people will have a more interesting and enjoyable experience next time. And I'll try and do this every week, yeah?
Yeah, I think if people have got questions, just stick them on your channel, Will. So basically, any video on Will's channel, just put a question in, and he'll get a notification.
Yeah.
And then bring it to.
What I'll try and do is put a post that's saying there's another live session coming up next Monday, and put your comments here, and hopefully there'll be a whole load before we start, and then we can keep answering them during the show. But thank you all for taking part tonight. Is there anything else anyone wants to talk about?
Just like and subscribe to Will's channel, guys.
Oh, yeah.
If you haven't already, you guys probably have. But yeah, just get on there.
Do I get to say smash the like button?
I wouldn't.
Smash. I watch all these things my kids watch, and there's always people going, smash the like button. So, yeah, thank you very much for everyone. And I'll see you on Thursday, yeah? So
Yeah, cool. Nice one. Cheers, Will.
Now I'll forget to switch this off, and it'll be broadcasting for the next 4 hours or something. No, I'll figure it out. I think it ends down here somewhere. So, yes, wherever it is, help. Okay, I'm going to end Zoom, and then I'll end the live stream as well, I think.
Yeah, cool.
Okay, thanks again.
See you
Thanks for
Thursday,
your
guys. Take it
patience.
easy, yeah?
Bye then.
Bye-bye.